Brandon, I think you may have had this class a couple times before. You're one of the diehards, man. You're always at the Presidio training, so that's great. So we'll go through quickly. We're going to look at what to do when property is held by a family trust. We're going to look at the most common way that the title is held with a family trust. That's with an inter vivos revocable family trust. So a couple of items here, just as we start to get going. First off, I'm Tucker with Backman Title. I'm licensed in title and escrow, but I'm not really a tax guy. In fact, my wife does our taxes. Haha. I'm not licensed and a licensed attorney or anything like that, but we do deal with a lot of family trusts just in the escrow world. We're not trying to give any legal advice or anything like that, but what we want to do is make it as a real estate agent, you guys can be a little bit more prepared, a little bit more ready when you see this very common thing of property vested in a family trust, and that's for both a buyer and seller. So I apologize, I look like I'm laying in bed. I'm actually not laying in bed. I'm totally laying on my couch. I've had some arthritis pop up, so it makes it hard for me to sit down and stand up. So, man, I just thought I'd lay down. It's a whole hour, or well, won't be an hour, I think, but yeah, just gonna take it easy. So if you guys want to take off your shoes or whatever, you're more than welcome. Every trust that we deal with is a little bit different. And that's one of the great things about our trust code. It allows for things to be set up differently, which is great because every situation and every family is a little bit different. I'm going to bring up a PDF here, and it's going to be a copy of our Utah trust code. So our uniform trust code in Utah, it's 41 pages long, and it goes along, it's Title 75 of the code, 75.7. And then our probate code is another 254 pages. And you know, the nice thing about our trust code here is that it leaves things so open for people. So people, when they have a family trust, they can make some different plans for things. Now, our inter vivos family trust is just one type of trust. There's also these other type of things that we're not going to talk about, like a Medicaid trust or something like that. But let's just look at the most common type. That's the goal. So we're going to define offices, look at trustees versus successor trustees. We're going to talk about beneficiary rights and who has the right to your stuff after you're dead. And then again, we're going to focus on that family trust. So part of our code, this is how you get a CE class certified for core, by the way. You just use the Utah code throughout the class, and then, hey, it's like a guarantee. So in order to create a family trust, it has to have an intention to it, meaning that the trust has to be created for a legal purpose, and it has to be for the benefit of beneficiaries. In other words, people who are left behind after you've passed away. Now, when you create a family trust or an estate plan, it's not supposed to be a result of fraud, or you're not under duress, or it's not any sort of undue influence. So ideally, an estate plan or a family trust is made while the people who make that estate plan are of sound mind and are not under any undue influence. Now, I think we've all heard stories of people creating the family trust, or, you know, mom and dad signed something they didn't understand. For us, unless there's fraud that's been proven by a court, we usually assume that the trust that's been created has been done, hasn't been induced by fraud, duress, or undue influence. The creation of a trust, there's actually three offices when a family trust is created. There's the settler or trust maker. There's the trustee. Those are those that can sign for the trust. And then there are beneficiaries. And in a family trust, a lot of times the settler or the trust maker, the trustee, and the beneficiaries are the same. What makes a family trust different, though, is beneficiaries. So if mom and dad create their family trust, they can probably be the initial beneficiaries just fine. But upon their death, there's usually a triggering mechanism that helps transfer the assets of the family trust to further beneficiaries. So you can't make a family trust with just one settler, just one trustee, and just one beneficiary and have them be the same person or same people. So again, most family trusts are revocable. That means the settlers or whoever created the trust can amend them. They can change the trust at any time. That means if they sell one house, like their family home, and move into a patio home, they can assign those assets in and out of the trust without any problems. And the nice thing about having a family trust prepared and properly vested is it helps your family avoid probate after you've passed away, especially if there's correct beneficiaries and successor trustees assigned. So really, from a real estate perspective, the important thing to know is, well, who can sign for this family trust? And generally the answer is the trustee named in the trust or the person named in the declaration of trust. So we'll look at both of those things. Now, about family trusts, again, revocable, I keep using that word, it just means amendable. Inter vivos, when we use those words, inter vivos means the family trust was made as the settlers or the trust makers were still alive. There's other types of revocable trusts. They're called testamentary trusts. And those are created after after someone who makes a will has already passed away. So they're a little bit rare. Most people, when they have their estate plan done, they do a will and a trust at the same time. In the event a person only created a will, sometimes the court will allow a testamentary trust to be created as part of settling an estate. Again, they're pretty rare. Most of the time we're looking at that inter vivos trust. So people make trusts for lots of different reasons. The biggest one is to make your family wishes known or make your wishes known. I tell people, hey, if you can't control your kids while you're alive, you can totally control them after you're dead if you make a family trust, right? And that's one of those reasons that you have a family trust, so that whatever happens with your stuff is the way you want it. So that's great. So there's that's part of doing an estate plan. A lot of people won't have a family trust created. They'll just have a will. Now, the funny thing is, I have a will. It's really old, right? It was done after we had our first kid. Now I have 4 kids. Man, I can't keep track of that. But we still don't have a family trust created. So in our will designates who's going to take care of our kids and what happens with our house and things like that. But in order to make that will effective, the will would have to be probated. So it's one of these things it's a do what I say, not what I do when it comes to doing a family trust. Okay, a lot of folks think a durable power of attorney will work for their kids after they pass away, and it just doesn't work that way. A medical or a durable power of attorney loses its efficacy once the people have passed away. It just doesn't work anymore. So the nice thing about trust, again, is it can help your family avoid probate issues. And the funny thing is, the cost of creating a family trust versus the cost of probate, if it's a simple probate, are actually about the same. So it's kind of one of those things, if you're a family, you choose to pay for the attorney to prepare the family trust and get that done for you, invest the trust properly, or you choose to pay for a probate, and the cost, again, is about the same. So in order for your property, your real property anyway, to avoid probate, you have to vest that property into your family trust. And to do that, you have to record a deed. You record it from the current owners or the correct grantors of the property. You have the correct name and the correct date of the trust, and you should always use a warranty deed to do that rather than a quitclaim deed. The reason that you use a warranty deed when you're putting your property into a family trust is that a quitclaim deed will invalidate your title insurance, where it has the potential to do that. A warranty deed keeps the title insurance in place, and if it's a homeowner's policy, which most of the residential properties are, it actually passes that coverage to the family trust that was held by the individuals. So yeah, always use a warranty deed when you're going to and from a family trust. So here's our necessary elements. We're not going to go over this really too much. The reason for this slide is title companies are really good at preparing deeds, and attorneys are really good at preparing family trusts. But title companies shouldn't prepare family trusts, and attorneys really need to be careful about how they prepare deeds. Okay, and specifically making sure that there's the proper signatures and signers there as a grantor. So when you're listing property, and you guys probably do this already because you're Presidio agents, and that's what you do, you confirm who holds title to that property. And a lot of the Presidios we work with is down in Utah County, and that makes it really easy because the Utah County land records are all online and you can access them for free. You could also text somebody like Andrea and say, hey, Andrea, can you help me figure out who owns this property? We can get into the abstract and send you the current vesting deed that will help you figure out who owns that property. We can also help you with the property profile, the proper plat map, the dedicated plat, and an abstract, so you know how that title is being held and what loans or liens are against that property. Here's an example of a county abstract in Davis County. I want to caution you a little bit when you're relying on ownership records from the MLS or from the county treasurer or assessor's office. If you look at this one, it says Barbara D. Houghton trustee is who's getting the tax notice. The actual owner of that property is the Barbara D. Houghton Family Trust. Okay, so if you're taking a listing, looking at an abstract versus a vesting deed, you need to be very careful about who you have and how you have them signed. Treasurer's office will just take the minimum amount necessary for the mail to get to the right place. They condense the data from the deed down into something that will fit onto a label, right? The MLS does the same thing. It doesn't have the full name of the owner of the property, of the vested owner. Okay, other FastWeb or other online property searches, Zillow is another one that will do the same thing. Sometimes they'll use, just for condensing the data, sometimes they'll use little things like this says Barbara D. Houghton and it says TE. I always think that means tight end because that's a football kind of thing. Probably, we all know it means trustee, but you know, there's some of these abbreviations that can be a little bit. So county information on the MLS might be outdated. The MLS does not automatically update when the real property changes hands. Okay, the county recorder does, but the MLS does not. And also remember that the county treasurer's office and the MLS tend to condense data. So if you look at this example, and this is kind of a real one, I changed the names to made up names, but this is something that I ran into. The MLS tax data said it was owned by Henry Ford, trustee. The online tax record says it was Henry and Wendy Ford in their trust. But when you looked at the actual vested owner and the deed, it was actually owned by two trusts, and the Henry Ford Trust was only a 40% owner. There was actually a different trust that owned 60% of that property. So just be careful as agents that you're getting those county records directly from the recorder's office rather than from the MLS or from the tax or assessor records. So we're going to skip through this next part because it's basically reiterating just what I said. So, hey, I think we just saved 3 minutes. Woohoo! So as you are getting into the listing, one of the things that you should ask for as a real estate agent, and if you don't want to interpret this yourself, that's great. Have your seller send this to your title company. We're going to ask for either a copy of the trust, or if that's not available, a copy of a certification of trust. So a certification of trust is not a full copy of the trust. It's a 2 to 4, maybe 5 or 6 page document that just identifies that the trust exists. Now, in our trust code there, that's 75-7 again, it says if we rely upon a trust certification that's been properly executed and notarized, we can do so. And even if it's not correct, we can enforce the transaction. So here's an example of this is one of the forms that Backman has of folks who don't want to give us their full family trust. It's a certification of trust. And it goes through and it answers these questions that the state requires, like this trust exists. Here are the settlers. Here's the acting trustees, and here's the powers they hold. And here's the trust, if it's revocable or irrevocable. And here are the powers of the current trustees. So certification of trust can be a simple 1 or 2 page document. But again, if your people don't want to give us their entire binder, you guys have seen family trusts before that are not in the 1 or 2 inch, they're in like the full 3-inch binders. Like, I don't even want to handle this anymore. Well, a lot of times we don't need the full thing. We just need that certification of trust. So here's a few issues that we run into as a title company. And as we go through the rest of the presentation, we'll talk about how to handle each of these. So one of them is delegation of authority, meaning who can sign. Is a trustee signing, or is a successor trustee or co-trustee signing? Another is that certification of trust we looked at. Dealing with co-trustees, And then what happens when a trustee or successor trustee passes away? They become incapacitated, or they want to or need to resign. We'll look at all these different things. Let's look at incapacity first. That's a fairly common thing. Mom and dad will create their family trust while they're of sound mind, and they have their property vested and everything works out great. And then for whatever reason, they become incapacitated. And the trust code is pretty open about what incapacitation means. And so who's qualified to determine if somebody has capacity? That means the mental or physical ability to sign on behalf of the trust. Well, doctors do. And most of the time, a family trust will have a triggering mechanism. These are who can decide whether or not I have capacity to sign. Okay. The other thing that determines capacity is a court order. And we look at this with guardianship and conservatorship all the time. Now, the difference between guardianship and conservatorship is guardianship usually deals with minor children. Okay, that's the area of court cases that we see guardianship, where a conservatorship is generally for someone who's over 18 who has lost capacity. Now, there's a little bit of gray area in between those, especially if you're dealing with somebody who's developmentally disabled. But between guardianship and conservatorship, that's the main difference. Okay, so we really need to be careful about determining that for ourselves. The courts have held that unless somebody is declared incapacitated, they have capacity. So when you're dealing with that, don't assume that a person doesn't have signing capacity unless a doctor or an attorney has said that they do not have that. So it's one of those areas as a real estate agent, you kind of sometimes have to walk a tightrope. My mom has lost her mind. She can't sign for herself anymore. And you meet mom and you think to yourself, yeah, that might be true. But until a doctor or an attorney has said they don't have capacity, it's hard to make that determination or that legal determination. And I would recommend that you kind of have to follow your instincts and then also get the proper documentation so you don't get in trouble later on. And in all this stuff, the best idea is to talk to your broker. Always run things by your broker. And then also your title companies. We've dealt with this probably more than you have, and we can help with that as well. Here's an incapacity affidavit when you're dealing with the family trust. This is just one of the forms in our computer that we use when they're dealing with incapacity. Usually attached to this, we have those notes from the doctor or those court orders. And this is something that records at the county when we're changing that title. So this just kind of zooms in on that document. We don't need to spend too much time there. So what happens when a trustee or successor trustee passes away? When mom and dad or mom or dad has passed away and now you're not dealing with both settlers anymore, you're dealing with one or only one trustee. Well, really it comes down to what does the trust say? Okay, sometimes a family trust will say mom and dad are the settlers, they're initial trustees. And if mom passes away, dad has full capacity to execute the trust. That's a pretty common thing. But every once in a while, you'll see mom and dad are the settlers and the trustees. And if one of them passes away, they nominate another kid to take their place, okay, or another professional. So again, we're looking at the trust document to tell us what to do and how to manage that capacity or that vacancy with the trustees or successor trustees. This is an affidavit of successor or surviving trustee. Excuse me. This is when mom or dad has passed away and the other has full capacity to act. This is the type of affidavit that we have. And your title companies are good at preparing these documents. We have to use them all the time. And they're a little bit different. Like this affidavit of surviving trustee is certainly different from this one for incapacity. Okay, so you've got to be careful which affidavit you pull out and use. We're lucky at Backman because whenever I have a question about successorship or capacity, I just forward it on to our attorney and he gets right back to me. In fact, I was on the phone with the attorney right as class started. I said, hey, I got to go. I got to teach a class, but it's great to have that resource. So let's get into a really common situation where you're dealing with a successor trustee, meaning it's a situation classically where mom and dad are the initial trustees. They've passed away and now one or two or maybe all of the kids now are successor trustees, and they're selling mom and dad's house to liquidate the estate. It's a fairly common thing. So let's pretend that we are successor trustees of our parents' estate, or maybe even your client is. A couple of things to keep in mind as you're dealing with this. One of them is a legal principle called cypress. Now, cypress means that as the successor trustee, or you could call it the executor of your parents' estate, you need to follow the instructions as best as you can. The other thing that you need to remember as a successor trustee is you can't be a spendthrift. You can't waste or steal or squander the assets of those estates. Your duty is to protect those for the beneficiaries, for the people who are supposed to benefit from the estate. Now, how do you prove that you're following the trust instructions and that you're not wasting money? Well, you keep great notes and you keep great paperwork. Now, luckily for us in the real estate and title world, how great we are at generating paperwork. Oh man, that's what we do. We kill so many trees. Even with electronic stuff, we are still killing trees, man. We generate a lot of paperwork, which is really great. So we're looking at who can verify that for the trust by what the trust says. One thing about a family trust or an inter vivos trust is generally you can't use a power of attorney, or you can't assign power of attorney as a successor trustee, okay, unless the trust gives you permission to do that. And most trusts don't give permission. I've only seen one or two that give successor trustees permission to assign a power of attorney. Coincidentally, I'm dealing with one of them right now, and it is a total nightmare. But that's another story. Oh man, if you're looking at land in Salem, let's talk. Woo, okay. So let's look at these situations where a successor trustee or trustee signs. Well, they've got to sign as trustee at listing. When the offers come in, they have to sign those repsine addenda at settlement. Okay, when they're handling the instructions at settlement, or when they're handling tax consequences, when they're dispersing proceeds, when they're doing their final documentation, that's all different times when a successor trustee has to sign. And they're usually signing their name, comma, successor trustee, which can be hard. So with my little medical issues, I've developed some arthritis in my hand, and it's hard for me to sign right now. It's hard for me to sign my name. So for me to have to sign my name, comma, successor trustee, it's not an ideal situation for me. So one of the things that we've seen realtors do in the past is they'll try and make it easier on their clients if they have issues like this. They'll put this on an addendum to the contract that says, okay, let's clarify one, who the seller is. And in this case, the seller would be my family trust, right? And the successor trustee of that family trust is named. And then you say something like, if they sign this way with their signatures and their initials, it's understood by all the parties they're doing so in their capacity as a successor trustee. And by the way, for anyone who's involved in this transaction, if you're the buyer, the seller, or a lender that's involved, we'll give you evidence of capacity. In that case, you could have someone just sign their initials on the contract and things like that. It would be understood by all the parties that they're doing that as successor trustee. It saves them from signing that little bit. So we're going to fly through some details from the Utah Code just about successor trustees and what you're supposed to do. One of the things we're going to talk about just briefly is resignation of trustee. So sometimes in an effort to be fair, what mom and dad will do is they'll make all their kids successor trustees. That's fair, right? All your kids have to suffer equally. Well, successor trustees, they have to sign everything. We just talked about that, right? They've got to sign at listing. And it's not always easy to have, 4 or 5 kids sign every single scrap of paper, especially when some of them just aren't into it. You know what I mean? Generally in a family situation, especially if you have a lot of kids, you have a few of the kids who are really invested in getting mom or dad's house sold. And then you might have 1 or 2 kids who are just like, show me the money. When everything's done, when the house is cleared out, give me that check, baby. I don't want anything else. You guys have probably seen that in families before. If you have multiple trustees, trustees can resign. So we've got an example of a trustee resignation form here. And if you let, a lot of times people who are successor trustees, they're also over here as beneficiaries. If you resign as a successor trustee, you're still entitled to the money as a beneficiary. You're not giving up your rights. So we use this trustee resignation a lot of times. I have a client who's a broker, real estate broker, and his dad married another lady. He was a widow, he was a widower, and the lady he married was a widow. And between them, they had 9 kids. It was kind of a yours, mine, and ours situation. Oh, listen, it's my dog in the background barking at the mailman. Isn't that wonderful about working from home? Anyway, we had 7 of the kids resign as successor trustees, and we just had 2 of the oldest kids, the broker and the daughter from the other family, sign, because it was just easier than getting 9 signatures every single time. So here's a little zoom in of that form, and it talks about how the trustee has resigned, but they're not giving up their rights as a beneficiary. Every once in a while, in a family trust situation or an estate situation, you'll have to have a trustee removed. Sometimes people just don't play well together. If there's a trustee who's committed a breach of trust, meaning they're not following those the instructions in that family trust, if there's a lack of cooperation, if they're unwilling, unfit, or they fail to act, you can actually have them removed. Now, the removal process can go a couple of different ways. Sometimes within the family trust itself, there's instructions about removal. If there's no instructions, a lot of times you have to have the courts involved to remove a trustee. So the code allows for that. Trustees can be compensated and reimbursed for their expenses, which makes sense, right? If you're having to cover the bills until mom's house sells as a trustee, you can be reimbursed for those expenses. One of the important things, though, is to keep really good records, like with receipts and how much things cost, just so that your beneficiaries don't accuse you of mishandling or being a spendthrift. So you have to administer the trust. You have to be loyal. You have to be impartial. You have to keep track of all of your costs. Okay, if you have special skills like a real estate agent does, you need to use those skills for the benefit of the beneficiaries and for the trust. You have to administer trust assets and trust property. You have to inform and report to the beneficiaries how much money or what assets are there in that family trust. And anytime those assets leave the family trust, you have to let them know, here's the current value of that family trust. And you need to do that at least yearly. Okay, yearly, if the family trust is open and you're a successor trustee, there's a requirement in the code that says you need to do a yearly report. Now, most of the time, estates are settled within a year, right? You sell mom and dad's house and you do a final report, and that's okay. But other times, mom and dad might have multiple properties, and it takes a while to liquidate all those assets. You can be one of those trust fund babies that you hear about too. You can say to yourself, you can say to the successor trustee, hey, I don't care what's happening with the assets. Just give me the money. Don't bother with the report. If you have that in writing as a successor trustee, you don't have to tell them anything anymore, which is great. So if you're a successor trustee, if your client is handling your mom and dad's estate, or if you're handling your parents' estate, it's terrible, right? For your clients, it's terrible for you when a family member dies, especially a parent. Some of the things that you have to do in addition to getting the funeral done, cleaning out the house, is gathering trust documents and evidence of authority. Okay, you're coordinating with anybody who's named an executor or personal representative. And you need to keep track of those notes, meetings, and conversations. So my grandmother passed away in August, and we've slowly been cleaning out her house. There's been some hurt feelings in the family because one of the kids went and started cleaning out the house without the other kids. Now, I've been to my grandma's house, ever since I was young. There's nothing in there that I want, right? I just don't want any of grandma's stuff. I just don't need it. But it did cause some hurt feelings within the family. So those notes, meetings, and conversations and just communication can be critical between family. So as a successor trustee, you're locating assets. You're collecting life insurance. And this is one of those things you do as a realtor. You obtain those date of death values for trust assets. You identify those liabilities and make sure those liabilities are continuing to be paid. You have to file federal and state tax returns. Generally, a funeral home will help you with Social Security and things like that, but that's one of those things to keep in mind as well. If the assets are encumbered, like if mom and dad's house has a mortgage on it, you need to make sure the house does not get foreclosed on, and so you don't lose the equity in the property. Okay, you have to publish a notice to creditors. I'm going to share my screen in another different way. We're going to look here at utahlegals.com. Utahlegals.com is kind of fun because it's any legal notice published in any newspaper within the state. I went there this morning and I typed in notice to creditors. And you see this in probate all the time. You also see it when somebody has passed away and their property is held by a family trust. You see this one for the Gwendolyn McPherson Family Trust. It's the same process. Now, the reason that you publish notice in the newspaper is for creditors that you don't know about as a successor trustee. Okay, if you publish notice to creditors for 3 weeks, it cuts off their claims after 90 days, meaning if you get a letter after 90 days of publishing from a creditor that you didn't know about, they're entitled to no money from that estate. Okay, if you do know about a creditor, meaning mom and dad gets a credit card bill from Kohl's, or something like that, that's a creditor that you've received notice of. You need to send them a copy of the death certificate. And when you mail them that, they'll send you a notice of final claim or something like that, a final bill. Or a lot of times with credit cards, they'll just write the debt off and you don't have to worry about it anymore. So for the creditors that you do know about, you're sending them a copy of the death certificate, okay? For the creditors that you don't know about, you're sending them, or you're publishing in the newspaper to eliminate their right to make a claim against the estate. The nice thing about being a successor trustee is you're not liable for debts that you don't know about, okay, or debts that your parents have incurred. So that's a good thing. Okay, again, you're looking to invest final assets or trust assets, wrapping up trust business. You're doing an inventory. You're filing tax returns. Does this sound fun to anybody? No, it's not fun to do this at all. So here's a few don'ts. If you're a successor trustee, don't mix assets. It's the same principle, right? If you have a real estate trust account, you never want to put somebody's earnest money in your own bank account, right? It goes into a separate account where you know where all the money's coming from and where all the money's headed to. Don't play favorites unless the trust tells you to. Don't hesitate in getting advice. You can actually have the trust pay for getting legal or tax advice. You don't want to make a mistake that way. So we have a little checklist that I'll show you here before we go. But if you're an agent, make sure you know who the vested owner is. Figure out if you're dealing with an inter vivos trust. Get legal advice or help from your title company if you need that, or from an attorney. Figure out who can sign. Help the trustees out by keeping good records. Remind them they're acting for and in behalf of the family trust, not for themselves. Come to settlement with the EIN number from the family trust or from the last deceased social security number. So if mom and dad have both passed away and dad died second, you're bringing dad's social security number with you to closing. Okay, address the buyer side concerns about a capacity so that they know that the signers have capacity to sign that and sell the property, sign the REPC and sell the property. I love it when agents come with all the copies to settlement because that allows us to create one binder and one book for the successor trustees to do their final reporting. Okay, help your clients know that money that they get should not go into their own account. They should set up a separate account for that family trust, right? There's a few additional resources like the Utah Bar can help people who are indigent or who don't have any money. There's also the estate planning section of the Utah court system that is a really, really great resource. Another thing is the legal hotline, talking to Curtis and those at the UAR, they're always a great resource. Now, we're not going to spend any time talking about the revocable transfer on death deed. I know you were really looking forward to it. I love the revocable transfer on death deed. I think there's only been 4 of them recorded across the entire state. So I know you're going to be disappointed, but instead I wanted to go over and look at a couple of these things that we have for you. And I actually put these documents in the chat. If you go into the chat, you should be able to download them. So let me go ahead and share my PDF screens. One of the things that we want you to have is this little sheet. There's 5 pages or 3 pages to it. The first page is it goes all over these things that we've talked about, how to work with a successor trustee or personal representative of an estate. Has those do's and don'ts, and it tells you as an agent those things that you can do to help successor trustees as they're moving through that process. Okay, so just those things that we talked about. Okay, the second page is all about conveyance types. Okay, what's the difference between a warranty deed, a family tree, and it goes over personal representatives and guardians deed and things like that. So some of those things that you went over in real estate school that you might not remember. And then the third page goes over tenancy. Okay, what happens when a trustee dies or when a sole owner of the property dies, and what to do when property is held in a family trust. So again, that's in the chat. It's available to download. Also in the chat, I put a full copy of the slides from today. If you want to download that too, we'll have it for you. We're going to finish about 15 minutes early. Does anybody object to finishing early? I don't think anybody ever really does. Maybe Brandon, did you want to stick around for another 15 minutes extra? Yeah, I can tell that you really want to. Okay, before we wrap things up, guys, does anybody have any questions? No? Okay. We'll see if our Presidio training folks are still there. Yeah, go ahead.
All of these resources, did you say they're in the chat?
Yeah, they should be in the chat there for you. If not, okay, I'll send them to Presidio and they can forward them back to you if that works.
Okay, I don't see them in the chat, but.
Ooh, let me reopen the chat and I'll put them in there again. Hold on one second. That means I have to figure out Zoom, which is always complicated for a Luddite like me a little bit. So let me go back into the chat here.
Thank you.
Oh, you bet. Okay. Sorry, this will just take 1 second again. Participants can whatever. Okay, that's fun. I think I'm the host now, so there's a whole bunch more things for me to choose from. Sorry, this will just take me 1 second. Okay, the first one is called Class 11, and I just put it there. And then let me put in the full copy of the slides as well. So poor Andrea, she's been with us as we figured out this Zoom CE stuff a little bit. And she has to sit through, how many times do you think you've had this class, Andrea? Like 12?
Hey, I really enjoy the classes, so I always learn something new.
Oh, well, that makes it fun. Guys, we are all done. Does anybody have any more questions? Were you able to download those things okay?
Mm-hmm.
Oh, perfect, guys. Thank you so much. I'll send a little request to our host.
Give me 2 minutes to be able to download those. I'm trying.
Oh, you're good, Brandon. I'm not going to end anything. I know the family trust one especially is a little bit bigger file, or the full copy of the slides. And you can always text Andrea if you lose those things, or send her an email. She has access to them, and we're just happy to help with you guys. Thank you so much. And thanks for putting up with me laying down on the couch while I'm teaching a CE class. You can't tell, but I'm totally rocking my basketball shorts too. It's a good day for me.
I'm putting in my phone number if anyone needs any additional information, and then my email address.
Oh, you're great, Andrea. Thank you. Guys, I'm set to teach again in April. So we'll see you then. The insurance department only allows us to teach once every quarter. So we love Presidio. We love your agents. You guys do such a great job. You're always so prepared. The great thing about working with a Presidio agent is by the time their clients come to settlement, they're ready to go. I mean, they know exactly what to expect. And as an escrow company, a title and escrow company, that's the best kind of clients, because those are the most fun closings that we have. Okay, Brandon, is it Carmina?
Yes.
Everything, did you guys get those downloaded okay? All right, guys.
I think so.
I'm going to go ahead and end our presentation. I think we're all done. Thank you so much.
Thank you.
Thank you, Tucker. Thank
Guys,
you, everyone.
Hey,
Thanks.
have a great day, guys. Thank you again.
Thank you. You too.